It is day 3, and in this video, the prosecution will rest and we'll find out who the defense is using as witnesses. Now, I did get spoiled a little bit, I don't mind, about the level of her intoxication in the blood test, and we also get that number in this video. So we begin with the defense not having a problem with the police interview they were asked to review overnight. The first prosecution witness is a 14-year-old who was at the party with the mother of the children who died. Says it's his aunt. He played games and did some fun things at the party, and a car went through the building. He heard it, somewhat remembers it. He was in the main party room, and he woke up on the floor. He woke up in that walkway after the car hit. There was like a doorway. He was in the walkway after that. A different room, kind of. He couldn't walk. His leg was hurt. He took an ambulance to the hospital. He had a broken leg, needed surgery, and he got surgery. I think this is the person that you see on the surveillance footage with the severely broken leg. I didn't even recognize it as a leg at first. I thought he was pinned by something else. Next up is a deputy who's now retired. He's the one who picked up the blood kits from evidence, did no stops or anything while having the kit, and delivered it to a lab supervisor and technician. It was a 2-hour trip. Cross-examination. He knew whose the blood kit he was transporting belonged to. It's normally done by mail, but this was personally transported. There was no ice pack to keep it cool. He doesn't know what the temperature was. He signs it in, and then it's not his problem anymore. They handle it. The next witness is a phlebotomist. So as you can imagine, this one is going to be extremely important. She is the one who drew the blood from the defendant. She explains the process. The blood draw happened at 6:35 p.m. She checks to make sure they weren't expired before doing it. Expiration date was questioned before. There are preservatives in the tubes. Everything is sterile. There was no problem filling the vials. She inverted the tube a few times to mix the preservative. The deputy also verifies everything is correct before putting it back in the box, and she recognizes the defendant. Now, here comes the cross-examination, and I need to warn you a little bit. When I do some of these crosses, it is going to sound like I am maybe mixing up the order of what's being discussed, but he really is just scattershotting everything. I just really want to make that clear. I really had a dislike of the defense attorney on the second day. I highly recommend you watch my video on that. But this one, I don't know what he's doing. It makes no sense, and I can't imagine it looks good. Maybe he's hoping something comes up. The witness had spoken to someone at the prosecutor's office before this point, only spoke to them this year, and that she may be a witness. The prosecutor's office called her to make sure she was here today. A man from the prosecutor's office walked her in. The witness doesn't know the building layout at the courthouse, but the defense is basically at this point, the defense is trying to get her to maybe spill that she said something or was told something from the prosecution she shouldn't have, and she doesn't know the layout of the building and it's not really working. The judge has to ask them to not talk over each other. The witness is visibly annoyed by the defense. I'll put it that way. The prosecution and this witness discuss nothing about the case. She could do legal and normal blood draws. The only difference is the deputy is in the room. The witness is not a nurse. She has a certificate and is registered with the state, not a degree. She works alongside nurses. She doesn't know where the blood for the patient goes. The defense asks about her giving blood, and she has to explain to the defense attorney that she doesn't give blood. The defense asks if she's ever seen the nurses give blood to a patient that needs blood. She says no. He was mentioning something about refrigeration. He's really trying to make certain things stick that aren't working. She has drawn blood at least 5,000 times since the defendant. He asks if she specifically remembers this case, seeing the preservative, and she said yes. She goes by memory. There aren't notes. They invert the tube. He tries to get her to talk about what happened. She says the video. She hasn't seen the video, but obviously whatever happened in the video is correct. Inverting the tube once or twice. She does blood draws for inpatient, not in the ER normally. Defense is basically trying to trip her up now on what type of blood draw she does. She does blood draws all the time. The defense apologizes because it was really obvious that he's harassing her at this point. I don't know another way to put it. and kind of needs to apologize, not really for her, but for the jury. Hands her a document and asks where on the sheet does it say she did this under a doctor. She reads it, and it's blank where you would list a doctor. Finally, the defense has something they can work on. It should all be filled out before it's signed. The defense wanted to show the jury. The judge says after they're done, they'll get everything. Defense says there is no proof she worked under a doctor. Prosecution objects, says she testified she worked under a doctor, and there's no evidence she was a rogue phlebotomist working in the hospital that day. Says the defense is mischaracterizing. The defense kind of gives up at that point, and they say they're done. There's a redirect. The prosecution asks if the witness has ever worked in a hospital setting not under the supervision of a doctor, and she says no. Defense objects, saying that only this date and time matters. The prosecution says this date and time is included in the wording of ever. And the judge agrees, objection overruled. It is a procedure. She has always worked under the authority of a physician. She did not forget to do the right name. Because she was called down to the ER, she did not know the name of who was in charge. She knows for a fact there was a DO running the ER. This is the only paper she fills out on her end. There are other documents filled out after she leaves. She doesn't know the specifics of those documents. The defense tries to object to this questioning, but the judge finds it proper and overrules. More questions about inverting the tube and how it's typically done. Defense gets to come back up. She says she doesn't know the name of the doctor she was under in the ER that day. She doesn't know how many times the tube was inverted. She didn't see the video, and the judge just says it's up to the jury. They saw the video. She didn't. So that was a flop. The best they got was that it didn't have the name of a doctor. Maybe it was supposed to. It had a spot for it. It didn't. Next is a forensic technician. They discuss her education, verify her resume. She explains getting the hand-delivered blood sample. She explains the procedure used. She shows how they inspect what is given in the paperwork. Everything appeared to be normal, no leaking, the tubes are intact, labeled property, all protocols are followed. She explains the tamper seal on the box to show it wasn't tampered with. She explained it who she handed off to. Defense is up. Defense asks if her only job was to get the toxicology kits. She explains normally a kit is taken into storage, but this time it was expedited, so it was hand-delivered. Normally a kit is put into a refrigerated storage. Next is a forensic scientist. She works in the accredited lab. She has a bachelor's in training. She explains she has tested over 12,000 blood samples for alcohol. She's testified in court 38 times. She confirms her resume. She was given the specimen by the previous witness. It was, again, hand-delivered due to the rush. She explains the tubes and the labels matching the defendant's name. She explains the process to test. Blood samples are all run 2 times. The devices are calibrated each run. The methodology is explained. The instrument was run overnight. They do a bunch of different samples in a batch. And then we get to the important part. She verifies the analysis of the defendant's blood. 0.18. Let me repeat that. 0.08. 0.18. Sorry. The legal limit is 0.08. She is 0.1 over the legal limit. That is very drunk. The witness explains elimination rates, but the defense wants a sidebar partway through it. Basically, we've heard similar if you watch the Sarah Boone case. I believe it was talked about how quickly alcohol leaves the body. The average for an adult female is 0.018 per hour. Varies by person, but it's an average. Cross is up. Defense is up. And honestly, they need a miracle because we have a 0.18 taken 2 to 3 hours after the crash. So when you think about the elimination rate, it's even higher. Now we don't know how much higher, but we can essentially guarantee without question, there is an elimination rate. So it exists. So her blood alcohol at the time of the crash was above 0.18. Defense words it as when you're talking about the elimination rate for whatever reason, He talks about it being variable, everyone's different. He questions how the instruments work to get the readings. Now, there's a lot of talk about the way the instruments work and like asking for minute details that I'm not going to go into because I don't find them all that relevant. If you're super interested and don't know how it works, you can of course watch or look it up. And it's him again fishing, right? This is a fishing expedition. He brings up the chromatographs to the expert, which is the graphs of the readings, and explains how the readings on the machine works, and it mentioned it went tested overnight. And then he questions about the effects of acetone in blood. And this is a new thing he's pushing. It isn't ideal, to have acetone in your blood. The defendant had a trace amount below the calibration curve. So basically the test says, look, there's acetone here. We are not able to detect how much, but we can tell you it is under a certain amount. So that was there. Defense points to a blown up photo. This is really important because the defense keeps trying to stress the size of these peaks because obviously the jury is going to see this. It's blown up because it's so small, and it keeps getting repeated, and I believe it's in my notes 1 billion times, but he is taking something that's, let's say it's this big, and it's a blown up photo to this big and saying, look how high it is. It's not how that works. Sometimes acetone like this is found in diabetics or ingested. People can ingest it if they like drink nail polish remover. But this is not reportable levels. The witness is asked about fermentation causing acetone. She doesn't know anything about it. She never studied that. Defense keeps saying it's a high amount, with the witness repeatedly correcting him it's not. That literally the reason they have to blow it up is because it's such a small amount. It would have to be in much higher values to, for example, kill you. Acetone is found in nail polish. Defense asks if acetone is in rubbing alcohol, and the witness says no. The defense asks if she's sure, and she says yes. I have never seen rubbing alcohol that says acetone on it. Let me know in the comments, I guess. Redirect. But before the prosecution can redirect, the defense comes back up to ask about if their testing is only as good as what was delivered to them, and they say yes, and the prosecution's a little annoyed, and now we're back to the actual redirect. Nothing was abnormal about the sample. All 4 results were similar and in the acceptable ranges of each other. Acetone this is important. Acetone cannot affect the ethanol reading. So this test showed 4 different types of alcohol, and they do not affect each other. The test shows a 0.0002 of acetone. It's measured at the same quantities, like, I don't know if it's milliliter per whatever as ethanol, but it isn't even reported until 0.01. Prosecution says they can't do the math to see how many times that would be. It's 50. The defense is back up, verifies the reported number would be 0.01 if they report it, and the witness has to explain again, we can't report anything below that because we can't verify the accuracy because they don't look that low. Defense tries to ask about fermented blood, but it's outside the scope of the redirect, so it doesn't get answered. Next is a supervisor of the toxicology unit. So at this point, in my opinion, they have completely flopped, right? Like, that blood test is the smoking gun. And the acetone thing I don't think's working. I don't think it's going to work on people. They're going to try with that angle. Trust me, he's going to try really hard. Next is a supervisor of the toxicology unit. They go through the qualifications and training. There was actually a mistake with the document handed to her. It was 2 resumes stapled together with someone else's. They break them up and submit it. She's an expert in forensic toxicology. She took the samples out of the refrigerator and did her analysis. This was a drug test. She followed the protocols. The method is explained to the jury how it works. She explains procedures to make sure it is accurate, like their calibration. She reviews the report, and she identified gabapentin is used for like seizures, was in her blood, which we knew that was admitted to, right? It is a central nervous system depressant. With alcohol, it can have its effects increased because alcohol is also a central nervous system depressant. Defense is up for cross. Witness has been there for about 15 years, but as a supervisor for one, the drug can also be used for pain as well as seizures. She didn't put anything in the tube. A private company does that. A test is only good as the sample. They keep things in the refrigerator. All their samples are stored there. It can slow drugs breaking down. The defense questions again, fermentation. She says yes, if any was taking place, but all the evidence is put in there. Defense questions how the concentration works, micrograms, nanograms. Basically, they're arguing about how the metric system works. That's the level of reach we're at, people. The metric system. The witness has never spoken to the defendant. The witness spoke to the prosecutor last week. He asked if the witness drove up with another witness. They said yes. They discussed who testifies first, but no specifics about the case. Redirect, again, talking about grams, nanograms. The witness explains that not every sample is fermenting. Yes, cold could lower fermentation in a sample that is fermenting, but that doesn't mean everything is fermenting. And the people rest their case. Now, after they rested, there is a defense motion, and I'm going to be very clear, there's only one source I could find for this part. The audio is really bad, so I'm doing my best. I don't know if the others were out of the courtroom or what, or they just didn't record in time. So the defense is, at this point, the jury's not in the room. The defense is talking to the judge. Some motion, I can't hear exactly what he's asking for, but we'll get there. The defense is claiming acetone is a fermented, possibly deadly solvent, which in the defense's opinion sometimes produces inaccurate results, which is not what the expert said. They said it specifically it is tested for and separated and can't be inaccurate. He says he understands the expert said it was accurate, though. Number two, the search warrant was not proper, as was an ex parte communication, so he wants all of that stricken. He asks for a directed verdict because it was a private property, so anything with alcohol is actually excluded under the charges they were trying to get her with. Prosecution's up. Prosecution says the court has ruled against his last 2 points already. The first point is that that he's not an expert, so his opinion doesn't merit the court's time. Defense is back up saying there's no proof of any type of intent shown, which is also required for second-degree murder. And prosecution responds, she admits to operating the vehicle. Blood and medication came in without objection. The cause and manner of a death was established as a result of the car collision. You have operation, intoxication, date, venue, resultant injury. Ample evidence of causation. The evidence showed they died due to her actions, that she knowingly created a risk of death or harm with her actions, specifically her blood alcohol limit. They have her above the super drunk limit of 0.17. She told the officer she was a 7 out of 10 for being drunk and shouldn't drive. They start citing case law for similar cases. Defense tries an analogy saying if someone sees a yellow light and they choose to speed through it, there's a crash, there's intent, but she didn't choose to attempt to murder someone. The judge says this happened in public access. The judge says the defense made a serious and reckless allegation of ex parte communication about the search warrant. The judge rules in favor of the prosecution. The motion for directed verdict is denied. The defense calls their first witness. This witness is a lieutenant who previously spoke for the prosecution. He is the one who interpreted the recorder from the vehicle. They go back through the previous testimony about the data. If you haven't watched it, it's in, I think, video 2. But basically, it's the black box type device in the vehicle. That's showing the fast reverse and then going forward until it hit the boat club. Image showing no braking, 70% or more on the pedal is full throttle. At one point, there is attempted braking at the same time as the throttle, but like the vehicle didn't brake, but the brakes were touched, basically. Talk of if he's ever investigated a situation where someone had a medical issue where they press both the brake and throttle. He said he isn't qualified to like do that, medical issue analysis. In this case, both brake and gas were on for about half a second at one point. Nothing. There's nothing there to help the defense. And then we get a new witness we haven't seen before. The bartender that served the defendant the wine. She does not personally know the defendant. The defendant met with her friends Brenda and Peter at 11 a.m. The witness did not see the defendant leave. The defendant got a cup of white chicken chili. There was no sandwich on her bill. There has been repeated talk of her getting a sandwich. There is no evidence of her sandwich. There was one glass of wine and water on her bill. The witness doesn't have a great memory of that day. But as far as she knows, she didn't serve her anything else to drink. And the witness says she doesn't recall if she finished the wine. The defense asks if she knows about the police report that says the defendant didn't finish that glass of wine. Objection for hearsay? How would she know what was in the police report? And facts are not in evidence. Sustained. Witness says she is positive she did not serve the defendant more than one glass of wine, but 2 people worked that day. That's opening a door, I have to say. Saturdays are busy. Again, opening the door, maybe something slipped through. The police closed the place down that night. No search warrant. They gave the police a receipt. Defendant paid cash and her other friends used card. That's why it was so easy to find the receipt. The receipt says water, glass of wine, cup of soup. The defendant did not come back that day, but her husband was there about 3. The defendant didn't seem drunk when she served her. She wouldn't have served her if she looked drunk. Objection for speculation, sustained. The defense starts digging through documents. He's looking for the receipt. He doesn't have it. Prosecution say they don't have it. The prosecution says they'll stipulate to it if he ever finds it, if it is what he claims it is. No more defense questions. State is up for cross. The witness doesn't know if the defendant drank before or after she was at the bar. The defense asks if she looked intoxicated when she came in, and the answer is no. And they're done for the day. Tomorrow, it sounds like, will be the final witnesses and the final jury instructions. So I don't know if they're going to get their expert in Florida or not. There's supposed to be some expert the defense had from Florida that was told he couldn't do Zoom. My guess is he's going to be talking about acetone. I'm going to be honest. That's my expectation, that somehow the blood made acetone. That's what it seems like the defense is all banking on. If this guy shows up, obviously he wasn't there today, I guess. I don't know what'll happen tomorrow, but they did tell the jury it'll probably be jury instructions by the end, so we might get the verdict tomorrow. Now, again, tomorrow is a game launch that I'm doing of like something I played as a child. Came out when I was like really young and I never beat it, and I'm going to be playing that. So I don't know if I'll be doing a video update. I might, especially if I see that like the amount of time in the courtroom is short, right? Like, it sounds like there's not much tomorrow. So if it's short, I'll try to squeeze it in as long as I'm awake, because I'm planning to be up pretty late tonight. But yeah, this is an interesting case. I find it like, I don't like the defense attorney and I don't like his defense, but I don't know what else he goes with. I don't think he has anything. I mean, when you're talking a 0.18 and her medication and her admissions, what do you do, right? I don't think there is a defense that makes sense. I don't think there's anything they can say or do that, like, works. I think the acetone thing is his Hail Mary, and I can't imagine it works. I can't imagine it, especially if this witness doesn't show up. It feels like everything he's done has flopped. And honestly, the most damaging thing that the defense did on their side, in my opinion, is what he did with the mother. I think that is bad. I think what he did with the mother is bad. I think what he did with the mother is going to be remembered. I think that is going to be one of the most memorable parts of this case for the jury. Trying to make it about himself in the middle of this trial, it's not going to help. I can't imagine it helping. But we'll see. I have read some comments since I wrote these notes, and a lot of people are just like, I don't know how she's not found guilty. Seems to be the common sentiment. I would agree. I would be beyond shocked if the jury came back with anything but guilty on all counts, but Stranger things have happened. I'll see you in the next video.